Hello and welcome to the new series of Drishti IAS. I am Pooja, and in this segment today we are going to discuss all about sedition. Now this topic is highly debated and highly in the news, so I hope you will find this topic interesting. From the perspective of prelims, we have facts that are important, and from the perspective of mains examination, GS paper 2 and GS paper 4 as well, you have to be concerned with it. So let's begin with the various topics that we are going to cover under it. These are the many topics that we are going to cover step by step, starting with the news. So why is it in the news? First of all, because the Supreme Court has asked the center to stop and prevent from going forward with respect to cases pertaining to sedition until and unless the center reviews it. Now earlier, the center said that just independent cases of misuse does not mean that the center will scrape off the act, but now it is saying that it is reviewing it. So this particular issue with respect to sedition, this is because the Supreme Court is considering batch of different petitions which have been filed by journalist Kishore Rechanda, Wang Khemcha and also Kanhaiya Lal Shukla and Trinamool Congress Member of Parliament Mahua Moitra. So they have asked the Supreme Court in their respective PILs to actually have an overlook over the Kedarnath ruling. So Kedarnath ruling is a very important ruling with respect to this particular topic. We will discuss about that as well. And the center is mulling a fresh review of the colonial law under this particular segment. We will also understand the challenges which are related to it. So first of all, let's talk a bit about sedition. What is sedition basically? Sedition is defined under 124, section 124A of the IPC. And it is said under this particular section that whoever by words, they can be either written or spoken or by signs, not only words, but signs as well. Okay, if somebody makes this kind of sign or that kind of sign which has some kind of meaning and that is inciting some sort of violence, that will be sedition. And or by visible representation or otherwise brings or attempts to bring hatred or contempt. First, excites or attempts to excite. Either excites, that means it has actually happened, or attempts to excite. And then disaffection towards the government that has been established under the law shall be punished with imprisonment for life, to which fine may also be imposed. So we know words, written or spoken, visible representation, signs. Attempts to excite or actually excites against the government that has been established by the law. It also has the provisions of punishment such as life imprisonment and fine that may be added. So where do we go with respect to sedition when it comes to explanation? First of all, disaffection. Disaffection actually means not only against the government but also exciting disaffection between different groups and disloyalty between different groups, and also comment which are expressing disapprobation of the measures of the government with a view to obtain their alteration by lawful means. By lawful means, if I am not very happy with my government and I want to change it by lawful means, or I want to have a judicial overview or overlook at the government's measures that have been taken by law, I am going through lawful means, that does not count sedition. Okay, that is not counted under sedition. Okay, comments expressing disapprobation of the administrative or other action of the government. If there are comments which do not excite or attempts to excite any sort of disaffection and I have actual concerns, that will also not be counted as sedition. So these are the basic 3 points that we have to understand. With respect to the history of it, let's go back to the colonial era when we got this particular section or section that is still haunting us. Thomas Macaulay, who drafted the IPC, he drafted the IPC basically in 1860, right? But mysteriously, by omission, it was said that sedition, this provision with respect to sedition was omitted. It was not taken with IPC. So in 1870, sedition was included as an offense. It was said that it was omitted. Section 124A of the IPC, that was under Special Act 17, and this had its provisions with respect to for punishment. It used to say the transportation beyond the seas, okay, for the term of her natural life. That means now at that time it of course meant life imprisonment. Now later on, it was amended to life imprisonment only after independence in 1955. That means the Constituent Assembly might have taken cognizance of it, right? With respect to, is this an appropriate law in the current setup of independent India? That was also done. So back in the time when colonial masters, the British government, made this act came into being, what did it use for? It used to quell the independence movement, specifically the very large independence movements, and they used to interpret it very liberally. It wasn't a very restricted interpretation, and many important freedom fighters were charged under it. Specifically, Bal Gangadhar Tilak, which occurred as a very important case, Queen Empress versus Bal Gangadhar Tilak, that took place in 1898. After that, Annie Besant was also charged under it. Jawaharlal Nehru was charged under it. Then Shaukat and Muhammad Ali, Maulana Azad and Mahatma Gandhi, in addition to them, Bhagat Singh was also charged under it. So if you know any other names, you can comment about them in the comment segment. Okay. So the Constituent Assembly, after I'm talking about when the interim government was formed and we were made independent. So with respect to Constituent Assembly, they debated sedition as an exception. This was debated because we had our fundamental rights of expression, free speech, but this was debated as an exception to it. And several members were very vehemently, that means very strongly, they disagreed with respect to keeping sedition as a part of the independent India's constitution, and needless to say, it was later on kept. Our judiciary was very well informed about the liberal interpretation with respect to this particular act. So in 1950, Romesh Thapar versus State of Madras. It was first time ever taken into cognizance by the judiciary in this year itself that sedition is actually something that needs to be interpreted very restrictively. It should not be a very liberal interpretation. And Justice Patanjali Shastri, he cited the Constituent Assembly's deliberate omission of the word sedition. He said that sedition, the word sedition, was something that the Constituent Assembly did not discuss. It was discussed as an exception to the fundamental rights, and word sedition was not used because, of course, our colonial past did not let us have that liberty or that proper leisurely stroll around this word sedition. So Tara Singh Gopi Chand versus the State of India in 1951 and Ram Nandan versus State of Uttar Pradesh in 1959. Punjab and Haryana court in this particular case and the Allahabad High Court in this particular case, they said that it's unconstitutional. Keeping sedition still in the IPC is unconstitutional, and that went to the Supreme Court in 1962, and then we had the Kedarnath ruling on sedition, in which a 5-judge bench, constitution bench, it upheld the constitutional validity of IPC section 124A. It, of course, took away the rulings of the previous 2 cases where it was said that sedition is unconstitutional in nature. Unless accompanied, they also provided certain facts about when to consider any action as sedition. Unless any words, spoken or written, signs, visible representation, they do not have any incitement or call for violence. If I am saying, okay, I do not like this government, I have a group who does not like this government, let's pick up arms and just go to the Red Fort and try to usurp the power. That is sedition because I am calling out for violence. And that is something that I'm inciting. I have not only attempted, but I have also incited violence. If people are going to take up arms because of me, I am seditious. Okay? And sedition only insofar as seditious speech tended to incite public disorder. Second important thing. Public disorder became a key ingredient in looking out for any case which is seditious or not. If there is no public disorder, it can be, of course, reviewed from the very fresh if it was sedition or not. Okay? Sedition, public disorder, yes, that I told you, it was read by the court. Then there were provided 7 guidelines with respect to thinking or taking into account if sedition is there or not. So the power with respect to lodging an FIR with respect to sedition because of the Kedarnath ruling lies with the police. Okay? So then only the FIRs are going to be taking place. So awareness is very important. What are the guidelines? Critical speech cannot be qualified as sedition. If I'm saying, I do not like this government, the measures are not very healthy and in interest of the people of the society. This is not sedition because I am critical in the sense I'm not telling anybody to pick up arms and just go and shoot somebody. That is not sedition. Okay, disaffection, hatred or contempt against the state. Okay, this is also something that is very open to interpretation. So these words should also be taken very restrictively, not liberally. But only speech that is likely to incite public disorder would qualify as sedition. I have explained that. Suppose we talk about Balwant Singh versus State of Punjab case of 1995. There was sloganeering in public spaces. This slogan is in Punjabi, but I will tell you in this English. Hindus will leave Punjab and we will rule. So this is something that is sloganeering, like Khalistan Zindabad, Raj Karega Khalsa. So this is actually in Punjabi. I'll read through in English. Hindus will leave Punjab and we will rule. So this is sloganeering. This is not like Banduk Uthao and anything like that. It was not said like that. Okay, so the court said that this is not seditious because it wasn't inciting any sort of violence. Okay, so in 2016 as well, Arun Jaitley versus State of Uttar Pradesh, in this particular case, the Supreme Court said that it is not seditious to write critically of the Supreme Court about the striking down of the provision with respect to NJAC. Okay, he was critical in his blog, Arun Jaitley, the former union minister. He was not happy with the court's ruling over NJAC, but it was not seditious. Like Vinod Dua versus Union of India, last year itself, when the government of India had its measures of COVID-19 came into being, journalist Vinod Dua was critical of the Prime Minister Narendra Modi with respect to the measures that were taken off for COVID-19. So that was also not seditious. It was, the FIRs were quashed. Okay, so what are the challenges? The basic challenge is, the first challenge, that it is a relic of the colonial era. So it actually still walks the pages, the ghost of the colonial past is walking the pages of the IPC. Why? Because it is still there. This is something that we have, kind of taken up as a legacy which needs to be reviewed, and the stand of the Constituent Assembly should be taken into mind with respect to when the vehement disagreement was there with respect to keeping sedition into being. Constituent Assembly was not very happy. So why not today? Why cannot we be fine with the fact that repressing democratic values is not in the best health for our democracy? Dissent is a safety valve, that has been said by the Supreme Court itself. And also, countries such as UK has already repealed sedition under the Act of 2009, its own act. And then we have USA, where in USA there is federal felony. Okay, in USA we have federal felony. So I hope you remember that the people who went to the Capitol Hill last year in 2021 January, yes. So there was this Capitol Hill where people of America and Donald supports Trump, they barged into the Capitol Hill and started, just dismantling things over there. So they are being charged under federal felony. It wasn't sedition. In Australia and Singapore also, they have repealed the law with respect to sedition. Okay, so disregarding Supreme Court's judgment, Kedarnath Singh case, it was said that take a very restrictive view of this sedition law. But it is not being done because there are numerous cases that are pending under sedition with the courts. So this is the challenge. Now, if we move on to the way forward, first is utility in combating anti-national and seditious activity. There are certain times when, yes, the security of India is very much threatened, and that should be taken into cognizance with respect to sedition. But the police should be made well aware of the fact what are the guidelines under the Kedarnath Singh case. Then judicial supervision is a must because Constitution is upheld by the Supreme Court. And we know that Supreme Court, if it does not intervene, then what is the entire concept of checks and balances are there. And then definition of sedition should of course be reviewed. It should be made restricted. It should be made less open to interpretation. It should not be open-ended, like what is hatred, what is public disorder. So all these things, what is disaffection, everything should be defined properly. Awareness, as I told you, not only for the police, but also general public, because civil society organization need to make sure that the general public knows what constitutes sedition and what does not. Okay, moving on. If we talk about our question, what is section 124A of the IPC? Critically analyze the misuse of this section in post-independent India. Okay, so that's it for today. Tomorrow we shall meet again with another segment. Until then, stay updated. Thank you so much for watching.